Michael Popok, Legal AF. Look at the time. Look at my eyewear. It must be time for Legal AF After Dark. The New York Attorney General is not holding back in trying to support and collect on that $500 million civil fraud judgment against Donald Trump. We break it all down. The new briefing, when the Appellate Division First Department in New York is going to rule, and when do the people of the state of New York start collecting on their $500 million against Donald Trump? All on a new edition of Legal AF. Take a listen.
Let's just talk briefly about the filing by the New York Attorney General. They filed their respondent's brief in the Trump appeal of the civil fraud judgment by Justice Arthur Engoron. Remember, Donald Trump had to post a bond to go through this whole appeals process. So Donald Trump filed his brief. Now, New York Attorney General Letitia James filed her respondent's brief, which is basically the opposition. And they talk about Donald Trump's fraud, where he's inflated assets and engaged in fraud by as much as $2.2 billion a year. And then it goes in to say that this court, the appeals court, should affirm Justice Engoron's ruling. Supreme Court's liability determinations are supported by overwhelming evidence that in each statement, defendant used a variety of deceptive strategies to vastly misrepresent the values of Trump's assets. For example, Trump valued his apartment as if its square footage was triple its actual size. He valued rent-regulated apartments as if they were unregulated. He valued Mar-a-Lago as if deed restrictions that he signed did not exist. And he valued golf properties by secretly including premiums that defendants represented were not included. Tellingly, on Donald Trump's appeal, he ignores these deceptions. Instead, Trump relies primarily on an argument that the Attorney General failed to prove the defendant counterparties relied on the misrepresentations to their financial detriment. But it is well established that neither reliance nor victims' losses, which are elements of common law fraud, are required by the statute here under Section 63-12. For disgorgement by the Office of Attorney General. Indeed, one of the statute's core remedial purposes is to protect the honesty and integrity in the commercial marketplace in New York by stopping fraudulent and illegal practices before they cause financial loss to market participants or broader harms to the public. So she kind of lays it out there, and it's 168 pages. I'm kind of summarizing it there. I won't go over all 168 pages there. But, she's saying, look, this is Justice Engoron got it right. There's overwhelming evidence. Trump's not even stating the law correctly here on Section 63-12. Affirm it. I think Popok, the appellate division will affirm. It's possible that they reduce the judgment, which with interest and everything is at $500 million. I could see them potentially reducing it by $100 million or $125 million based on what, I don't know, as the 12-year-old Noah said to Mike Lindell, trust me, bro, perhaps on just a trust me, bro theory. But we've seen them before kind of lower the amount of Trump's bond obligation, not the judgment, the bond obligation under kind of a trust me bro theory. So I can't describe the logic of what they did, but the law is clear. Justice Engoron's got it right. But I could see them saying, oh, look, we threw you a bone or two, Don. Not that he should have one, but they've shown an inclination to do that for. So I'm going to go with the 12-year-old Noah, and I'm going to say, trust me, bro.
Well, I've got time today, Ben, so I'm gonna read. I'm gonna read 148 pages. Page 1, preliminary statement. I was gonna do like a what's it called when you try to slow down the clock in Congress?
Filibuster.
Filibuster.
J.D. Vance and read Dr. Seuss while people are trying to get healthcare.
But I will make one point that I because you covered really well the others. The primary focus of her argument, the Attorney General's argument, which is the winning argument, is that they still, at this late date, refuse to understand how 63-12, the executive law of the state of New York, works, and why the sheriff of Wall Street, which is the Attorney General, has that power because it's the financial capital of the world. It is probably, as I've said before, the most robust, the most muscular set of powers an attorney general has about financial fraud in all of the United States, bar none. I can't think of any equivalency to 63-12, the executive law. Under that executive law, you stop crime before it happens. Let me put it another way. You stop fraud before there are victims. There doesn't have to be a victim of the fraud if you're operating a fraudulent scheme on an uneven, unlevel playing field where you set the rules and your counterparties are harmed or not harmed. If there's a fraud that's operating, the New York Attorney General gets to shut it down through the court system under 63-12. It's not like common law fraud. That is a fundamental misunderstanding that Donald Trump's lawyers have had, a willful blindness for them to accept that truth since the beginning of this case. At every argument that they make with Judge Engoron, they demonstrated they refuse to acknowledge that this is not a civil fraud, common law fraud-based statute. This is a fraudulent practice disgorgement statute that can only be used by an attorney general. And that's the difference. In a fraud case, if I defraud my neighbor, no, more likely, my neighbor tries to defraud me, there has to be a victim. I have to reasonably rely on their fraudulent statement or scheme or artifice to my detriment, and therefore there I am victimized. But as Letitia James pointed out at the top of her brief, there doesn't have to be a victim of the crimes. Donald Trump keeps saying everybody on the counterparty side wanted to do business with me. All the banks love me. All the banks loved. I paid them all back. All the insurance companies, I paid the premiums. All the properties I bought or sold. Nobody was harmed in the making of this financial fraud, and therefore you should just let me go, which completely misses the point of 63-12. I said it on a hot take recently. It's almost like that old movie that I loved, The Minority Report with Tom Cruise. It's the thought police. You can stop the crime before it actually happens. There doesn't have to be a victim. And that's the point. And maybe this doesn't work in Tulsa, Oklahoma, or in some other places, but it works in New York, which is the financial capital of the world with the Attorney General. And so she says in the first part of her brief, there's no need for a victim. There's no detrimental reliance. We're not talking about common law fraud. Now, part of the problem is the lawyers for Donald Trump, most of them that started this case don't really practice regularly in New York. Alina Habba, people forget, started this case. You know, they brought in some other lawyers towards the end and put her at the kids' table. But and even the new lawyers they brought in, most of them did not. Like Chris Keiss is a Florida lawyer, doesn't really know what 63-12 is all about. You know, and some of the other people they brought in were just there on a special admission into the courthouse. So it doesn't surprise me, but they've been taught this now for 2 years. They can read the case law. Some of the case law in the area of this particular statute has Donald Trump's name on it already because his Trump organization was nailed with a 63-12 by a prior attorney general, Schneiderman, in the state. So he knows the law. He should know the law. And even if there was a requirement somehow that there be a victim or detrimental reliance relying on it, there was enough testimony of Deutsche Bank and the insurance companies and the counterparties to Donald Trump to show that they demanded the personal financial statements that Donald Trump created falsely and relied on them. And whether it was the front of the bank or the back of the bank or the compliance department of the bank, they needed regular, updated, accurate financial statements, and Donald Trump didn't provide them. And neither did Eric, and neither did Don Jr., and that's why. And on this last part, Ben, so you have this brief, you got one more brief by Donald Trump, and then you've got that oral argument that's going to be in front of the Appellate Division First Department in Manhattan. I might try to get into that one because I'm actually a member of that particular court, and I like that courtroom. So that one is going to be happening in September as well. And then we'll get a ruling 4, 6, 8 months later. And what you alluded to earlier is that some people were annoyed or pissed off, even in our audience, that the Appellate Division gave Donald Trump a break in the size of the bond that he had to put up. Because the judgment was $465 million for disgorgement, meaning ripping away ill-gotten gains, clawing them back from somebody that should not have obtained them. That's why it's not damages, civil fraud damages. It's disgorgement, equitable disgorgement under this unique statute. Back to that point. again. And the appellate court said, well, because Donald Trump was crying and bleeding and upset that he couldn't scrape up the $465 million despite looking everywhere, even in the couch cushions, no joke there. And the court said, all right, 175 million, put up 175 million. Now people were like, oh shit, they just reduced the potential judgment to 175 million. No, they didn't. The 175 million is just, I think, a reflection that Donald Trump has a lot of exposed, obvious assets. A lot of them have his name on it. And there is a financial monitor that's been in place over every financial transaction, bank account, and asset of Donald Trump for the last 2 years. Her name is Barbara Jones. She's paid for by Donald Trump, but she's an officer of the court who reports to Judge Engoron. And so with the monitor in place, the independent compliance director in place, regular reporting to Judge Engoron in place, and assets all over New York and other places with Donald Trump's name on it, they were like, just scrape up 175 million. But I don't think that reflects. And we had a little bit of a debate. I can't remember if it was me and you or if it was Karen and me about whether that means they're going to take a red pencil or a blue pencil to the judgment and start lopping off things. I'm not sure that means that at all. I mean, I think Judge Engoron got it right about how to apply the statute of limitations, which was the only issue that Donald Trump won on an appeal. It was an issue about what transactions were inside and outside a statute of limitations. There was a 10-year statute of limitations, and it took a while for Letitia James to work her way through this prosecution. And some of the transactions fell off the continuum. They fell off the table as being stale, as outside the statute of limitations. Not all of them, just some of them. That's why Ivanka Trump, people will remember, she was originally a defendant in the case. She got dismissed because really the things she was involved with in 2017 and 2018 put her outside the statute of limitations. And so she left. And that's the reason. But now, with that in mind, I believe that Judge Engoron properly applied the teachings of that Supreme Court decision about the transactions and the values of things methodically in rendering his decision. He spent 4 months writing the decision from the time the case ended before the holidays in December until he issued the decision sometime in March. He had a lot of time to get it right, and I believe he got it right. Maybe could they lop off $5 or $10 million here or there? Yeah. Are they going to cut it down to 175 million from 450, now 500 million with interest? I don't think so. That's my opinion. Welcome back. That was Legal AF. That was me and Ben Meiselas. We do that every Saturday on a show we call Legal AF, and now you know why we call it that. Wednesdays and Saturdays. Wednesdays with Karen Friedman, Nick Nifolo, and me. Saturday with Ben Meiselas and me. And we do hot takes like this about every hour at the intersection of law and politics. We're practicing lawyers who don't blow smoke or sunshine, and we're almost never wrong. How refreshing. If you like that brand of analysis, you'll love the full-length podcast Wednesdays, Saturdays, 8 p.m. Eastern Time, right here on the MeidasTouch Network. And then you can pick it up on all audio podcast platforms as well. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.